Good evening and welcome to the seminar on contact post-final orders covering both private and public law. My name's Suzanne Kelly, and this evening I'm going to be talking to you in respect of private law, so contact following a final child arrangements order, orders for no contact, supervised contact orders, family assistance orders, and then in public law, contact post-adoption, contact post-care order, and then finally contact post-special guardianship orders, which of course are made in both public and private law proceedings. So turning first to the contact post-child arrangements orders, the law considers that the involvement of both the parents is beneficial to the child unless there is a risk of harm to the child which would prevent that. Both parents who have primary care and those who seek to spend time with their child have a responsibility to do their best to meet their child's needs in relation to the provision of contact, just as they do in every other regard. That was Macfarlane's view in Reed W, a case from 2012, in which he set out, quoting more fully from Sir Thomas Bingham's judgment and shorter judgment from Justice Wall's summary, that there is an overriding all else as provided by Section 1.1 of the 1989 Act, that the welfare of the child is paramount consideration, and the court is concerned with the interests of the mother and the father only insofar as they bear on the welfare of the child, and that it's almost always in the interest of a child whose parents are separated that he or she should have contact with the parent with whom the child is not living. And the court has the power to enforce orders for contact, which it should not hesitate to exercise where it judges that it will overall promote the welfare of the child to do so. This was considered again in Re H and B, where Justice Black stated at paragraph 62 that parents in the incident case would do well to read this postscript by Macfarlane in Reed W above as to the duties and responsibilities of parenthood, parents, and the need to make child arrangements work for their children. The case of Re H and B concerned an appeal against an order allowing only indirect contact between a father and his two daughters. The appeal was opposed by the mother and the daughters, who were separately represented. Difficulties had arisen with the father's contact after an incident at the father's home during staying contact, when his new wife, was rough towards one of the daughters, pushing her on the sofa and causing some bruising. Subsequently, the parents became more and more hostile towards each other, culminating in the children making numerous allegations against the father, including allegations that he had behaved in a sexually inappropriate manner towards them. A subsequent finding of fact hearing, the father was found to have been insensitive and unwise in his approach towards contact, and mother was found to have exaggerated and been untruthful about many allegations. The allegations about the father hitting the girls and being sexually inappropriate were not made out. However, by this time, the girls were hostile towards father and in need of therapy. At that time, 2011, it was decided that direct contact could not be restarted until the girls had progressed in therapy and there had been an opportunity for the findings to be explained to them. In the event, the therapy was delayed and then failed after 4 sessions. The findings were never explained to the girls, and when the matter returned to court in 2014, the girls were hostile to contact and direct contact was not recommended by CAFCAS. Father's appeal was that there had been inaction, prevarication and abdication of the responsibility by the family justice system. Mumby emphasised that it is not acceptable for a parent to shirk their responsibility to promote contact by sheltering behind an assertion that the child will not do, or even that the child is adamantly opposed to doing something, and that this applied whatever the age of the child. And that is set out at paragraph 74 to 75 of the judgment in Re H and B. In extreme cases where parents do not promote contact and parental alienation occurs, the court can transfer residence to the other party, and such a change is not regarded as a last resort. And this was the outcome of a particularly sad case, Re-X and others, children agreed transfer of residency, F&M and others 2021. Where in giving judgment, the court referred to this as one of the saddest cases that set out the damage that can be done to children when parents have separated. The court considered 4 options in that particular case, the third being transfer of residency to the mother, and the fourth being the children being separated with one child, going to live with each parent. There were 4 separate sets of proceedings in respect of these children who were 8 and 12 at their final hearing. And the proceedings went on for many years. There was a requirement for psychologists and interventions, and it makes troubling reading as a family practitioner, the damage that was done to these children. The children were transferred to live with the mother in that particular case. In Re-M, the ultra-Orthodox Judaism transgender parent, in respect of that was a father's appeal. He succeeded on an appeal on all 3 grounds as set out, and in particular that the judge at that time had needed to have a careful survey of the wide constellation of cultural and religious concerns, and the judge had ultimately lost sight of the paramountcy principle of the child's welfare and the need for contact. The judge had failed to evaluate why indirect contact and the giving of narratives to the children about their father's transgender status was in the children's best interest, whereas direct contact was not. And the judge had failed to exhaust the court's powers to attempt to make direct contact work. It refers then after to Re-L following that case, where Andrew McFarlane says that the judge must consider all the circumstances and choose the best welfare solution. And that is the situation that remains in respect of contact between parents and non-resident parents. Unfortunately, there are times when contact orders that are made by the court are not carried out and are not adhered to. The courts can make enforcement orders against a parent who is not complying with a contact order. In CH and CT 2018, the court considered what was necessary to make a child arrangements order enforceable. Excuse me. In this particular case, it was a case in respect of grandparents making an application for child arrangements orders, which the mother opposed, the children's fathers having been deceased some previous years. The court made an order, a child arrangements order for the grandparents to spend time with the child, and the order contained a warning which said, where a child arrangements order is in force, if you do not comply with the provision of this child arrangements order, you may be held in contempt of court and committed to prison or fined, and/or the court may make an order requiring you to undertake unpaid work, an enforcement order, and/or that you pay financial compensation. Additionally, the version of the order distributed at court contained the words warning notice at the bottom, but no words underneath those ones. The child's mother refused to comply with the order. The mother then appealed against the order and lodged an application for a child arrangements order. Before the hearing of the mother's appeal, the paternal grandfather applied to intervene in the proceedings in support of the mother. The mother's appeal and the grandfather's application were heard together before HHJ Lee on September the 14th, 2017. The judge dismissed the grandfather's application, and both the mother and the grandfather then left court. Then the judge dealt with the mother's application for permission to appeal in her absence, dismissed it, and made a costs order against her. At the end of October, the grandmother applied for an enforcement order pursuant to Section 11J of the Children Act 1989. The mother then filed an application to set aside the order of Her Honour Judge Lee, admitting that she had failed to comply with the order, but seeking to advance reasons for her failure. The applications came before Recorder Wilson on the 20th of February 2018, and at the end of the hearing, the Recorder delivered a short judgment and made a committal order in the standard form on Form N79, despite the fact that no notice to show good reason was ever served on the mother. On the 26th of February 2018, the mother filed a notice of appeal against the Recorder's orders, and she made various allegations of misconduct by the grandmother and raised various procedural points in relation to the hearing before the Recorder and in relation to the order the Recorder had made. The skeleton arguments were filed by the parties and the matter was listed before Justice Baker. In his judgment, he set out in detail the statutory provisions relating to the making of enforcement orders pursuant to the Children Act and the relating to the applications for committal for contempt pursuant to Part 37 of the FPR 2010 and Practice Direction 37A. And he identified the following errors of procedure in this case. 1. There was no application to commit the mother. That meant she did not have proper notice of the committal application. The only application having been filed was one of enforcement order under section 11I. The Recorder had erroneously assumed that that gave her the power to make a committal order. 2. Neither of the requirements for Rule 37.10.3 was satisfied. The mother had not received an application that identified separately and numerically each alleged act of contempt, including, if known, the date. Equally, there had been the applicant had not filed an affidavit in support, and there was a failure to comply with several requirements of Practice Direction 37A. Namely, 1, there was no warning notice, contrary to paragraph 10.2.4. The mother had not been properly served with the application, had no time to prepare a defence or to respond in any way, and there was no notice to make the mother aware of the possibility that criminal legal aid might be available or how to contact the legal aid agency or to give her any opportunity to obtain legal advice. In judgment, the following principles were extracted. That the court must be satisfied beyond reasonable doubt that the order has been breached. The court will not make an enforcement order if it's satisfied that the person had a reasonable excuse for failing to comply with the provision. The burden of proof lies with the person claiming reasonable excuse, and the standard is the ordinary balance of probability. Of course, in terms of burden of proof for committal, the burden is on the applicant, and that is beyond reasonable doubt. A child arrangements order under Section 8 of the Act can in certain circumstances be enforced by an application to commit the defaulting party to prison for contempt of court, as previously discussed. An order can only be enforced by committal if there is a penal notice that complies with FPR Rule 37.9. The notice must contain the words set out at paragraph 1.1 of the practice direction or words substantially to the same effect. It must be prominently displayed and it must be on the front of the order. And it's right to note that a penal notice and a warning notice are completely different. A penal notice under Rule 37.9 must not be endorsed on an order under Section 8 of the Act, including a child arrangements order, unless and only the court, on the application of the person entitled to enforce the order, has expressly directed that it be endorsed. And this contrasts with the warning notice, which must be attached to every child arrangements orders. In re a child, Macfarlane observed that the purpose of Section 11I is to alert the parties to the fact that all contact orders are potentially enforceable against those who may act in breach of them, and secondly, to remove judicial discretion as to whether attach or not attach a penal notice to any particular order. In the case we've just been looking at, the court found that the 2017 order was not capable of enforcement, and so the mother's appeal was successful. Moving on to orders of no contact. We see a child suspension of contact. That sets out the cases when there may be a suspension of contact. That particular case was one that was heard by Mumby, and he summarised the relevant case law as follows. Contact between a parent and child is a fundamental element of family life and is almost always in the child's best interest. Contact between parent and child is to be terminated only in exceptional circumstances where there are cogent reasons for doing so and where there is no alternative. Contact is to be terminated only if it will be detrimental to the child's welfare. And there is a positive obligation on the state and therefore on the judge to take measures to maintain and reconstitute the relationship between parent and child. In short, to maintain or restore contact. The judge has a positive duty to attempt to promote contact, and the judge must grapple with all the available alternatives before abandoning hope of achieving some contact. However, there are cases where contact, direct contact, is suspended, and the law of cessation of contact derived from the case of Re A, 2019. Following on from this case, the test that is now applied when considering whether or not the court should cease contact between a child and a parent is set out in Re J and M, a child, proceedings balance of harm. And again, it reiterates what pervades through most Children Act matters is that the welfare of the child is paramount. It is almost always in the interest of a child whose parents are separated that he or she should have contact with the parent with whom they are not living. And again, it reinforces a positive obligation on the state and the judge to take measures to promote contact. So the principles that have derived from the case law is that when there is a suggestion that there should be no contact or irretractable dispute between the parties resulting in no contact, that the court and the parties should consider the instruction of a child psychologist to examine the impact on the child should contact be stopped. And excessive weight should not be accorded to short-term problems, and the court should take a medium and long-term view. This is particularly important where there is acrimony between the parents, to the extent that a parent could be seen to be putting obstacles in the way of contact and influencing, whether it be directly or indirectly, consciously or unconsciously, a child's desire to have contact. The court has to dig below the child's wishes and feelings if they are expressed that they don't wish to have any contact. And again, it reiterates that contact should be terminated only in exceptional circumstances. And those principles are the ones that are now followed in most cases of child arrangements orders. There are occasions when the court will make an order for supervised contact only. Re A, a child supervised contact, also looks at section 9114 orders, or I'm not going to cover that today. And that provides valuable guidance on supervised contact in the judgment which was handed down in November of 2021. And that includes that in the ordinary course of event, supervision of contact should be regarded as a stepping stone to unsupervised contact. That said, as Lady Justice King's dictum Re S suggests, where appropriate, such a route should be deployed as a means of allowing a child to continue to have contact and a relationship with her absent parent. And this includes the case where the choice is not between supervised or unsupervised, but between no contact, no direct contact, or only supervised contact. And as such, the court can, if the facts of the case demand, make an order for indefinite supervised contact. That is a final order that does not define a pathway from supervised to unsupervised contact. Previously, in many a case, the courts took the view that a child's contact could not remain supervised indefinitely. And this now says that there are cases where supervised contact may be the only contact. There may be a pathway by which a parent has to comply with certain provisions or directions or work to progress it, but the court is able to make orders for indefinite supervised contact only. Of course, that brings on to how and who supervises and who pays for the supervision of contact. Previously, before that, it was considered that contact, be it supervised or not, was in the child's best interest, and therefore both parties would be expected to contribute towards the cost of the same. The new Domestic Abuse Act now makes provisions that if supervised contact is taking place either as a result of domestic abuse or as a result of the actions of the party having supervised contact, then the victim or the wronged party, as it were, should not have to pay or contribute towards supervised contact. So how can the court get around and assist the parties with that supervised contact? One of the ways is to make a family assistance order, and the power for the court to make that is found in section 16 of the Children Act, which provides that in any family proceedings, the court may make an order requiring a CAFCAS officer or a local authority social worker to be made available to advise, assist, and where appropriate, befriend anyone named in the order. The order is usually made for 12 months unless a shorter period is stipulated, but it can only be made if every person named in the order, with the exception of the child, consents to the order being made. A family assistance order cannot be made against the local authority unless the local authority agrees or the child concerns lives or will live within their area. And the family assistance order is usually made of the court's own motion. If the court makes a family assistance order with respect to a child and the order is to be in force at the same time as a contact order made with respect to the same child, the family assistance order may direct the officer concerned to give advice and assistance as regard establishing, improving and maintaining contact to such of the persons named in the order as may be specified. A family assistance order is the only way in which the court can compel a local authority to provide supervised contact in private law proceedings, as there is no power under section 11(7) of the Children Act to make orders against local authorities in private law proceedings requiring them to supervise contact. I'm going to move on to public law now and contact post-adoption. I briefly set out here what is the provisions of making an adoption order and what the court must consider. I don't propose to go through them. Safe to say that section 9 of the Children and Families Act 2014 introduced 2 new sections into the Adoption and Children's Act 2002 to govern post-adoption contact. So prior to the Children Act 1989 and the Adoption Act, excuse me, the leading case in respect of post-adopting contact was Re C. Following that, the courts adopted a cautious and restrictive approach in the face of applications for post-adopting contact, and this was considered in Re R. In Re C, it was stressed that in normal circumstances, it's desirable that there should be a complete break in contact between the child that's been placed for adoption and the natural parents, but that each case has to be considered on its own particular facts. And it also recorded that the court would not, except in the most exceptional case, impose terms or conditions as to access to members of a child's natural family to which the adopting parents do not agree. It was considered again in Re R, where the Court of Appeal reviewed the issue of post-adoption contact, some 4 months prior to the implementation of the ACA 2002. And in the course of giving the leading judgment, Lord Justice Wall looked back at the House of Lords decision in Re C, given some 17 years earlier, with an eye to the new adoption legislation, which is about to come into force, and said in summary that contact is more common, but nonetheless the jurisprudence is, I think, clear that the imposition on prospective adopters of orders for contact with which they are not in agreement is extremely rare and remains extremely unusual. It was revisited again in Re P, where Lord Justice Thorpe, Lord Justice Wall and Justice Mumby, so a very experienced tribunal, returned to the issue of post-adoption contact. And following a full review of the earlier case law, which concluded with the judgment in Re R, they went on to state at paragraph 154 of their judgment that section 46(6) of the 2002 Act of Parliament has specifically directed the court to consider post-adoption contact, and in section 26(5) Parliament has specifically envisaged an application for contact being heard at the same time as an adoption order is applied for. All this leads us to the view that the 2002 Act envisages the court exercising its power to make contact orders post-adoption where such powers are in the interest of the child concerned. It did not change the position. In Oxfordshire County Council X, Y and J, the judgment of the court, and then Lord Newberger gave the lead judgment there, concluded at paragraph 9 that paragraphs 147 to 154 of Re P were not intended to affect the application of the conclusion of the earlier cases, which were that the imposition on prospective adopters of orders for contact with which they are not in agreement is extremely and remains extremely unusual. I'm going to come on to Re B shortly. So I've just set out briefly on this slide what a person who wishes to make an application have to do. They have to obtain the court's leave to pursue their application. In deciding whether or not leave should be granted, the court must consider the extent to which such contact would disrupt the child's new life, the applicant's connection to the child, and any representations made to the court by the child or the adoptive family. And the court must look at the value of the child to a continued relationship with parents. By the ACA 2002, a parent who wishes to apply for post-adoption contact must first obtain the leave of the court to make such an application. So we go on then to consider Re B, which was the first case considered by the Court of Appeal since the implementation of the Act. And although the substantive appeal was refused in the case of Re B, the following is considered to be good practice when considering post-adoption. And this was what the court came to, having considered quite extensive studies in respect of contact between birth parents and the children, and the case law that had followed. And this is what they decided would be good practice. That adoption agencies, to ensure all prospective adopters and all adoption social workers fully understand the developing research when undergoing training and approval. And as previously said, it was quite extensive research that the court looked at. Re B sets it out very well and gives a really good summary and overview of where the court has come through and what it has considered in reaching the principles. They went on to say that in every case where post-adoptive contact is a realistic option, the local authority should file during the placement proceedings the best information available as to the pool of open adoptions nationally, and to ensure that this is specific to the subject children as possible. Social work and children's guardian to consider the significance of the research studies in every case, and the court to provide full reasoning in determining any Section 26 contact application. It went on to consider sibling contact and, as set out here, consider that sibling contact should be considered entirely separately from that between the child and their natural parents. and that finally an open and frank dialogue between the social workers, adopters and birth parents, and if sufficiently mature, siblings about the child's needs, with possibility a face-to-face meeting in this case should take place. The President, giving the leading judgment, was careful not to raise any of the listed matters to the status of being something which the Court of Appeal has stated should now be required in every case. And that's an indication as to the weight that can be attributed to that. However, he did go on to say it must be given that any social worker, children's guardian or expert who is required to advise the court will ensure they are fully aware of any current research and its potential impact upon the welfare issues in each particular case. And in conclusion, stressed that the position continues to be that applications for post-adoption contact, and save for there being extremely unusual circumstances, no order will be made to compel adopters to accept contact arrangements with which they do not agree. So what does that mean for practitioners in public law? Well, it's important for us to be aware of the current research in respect of post-adoption contact. If it's expected that the professionals working within the field are considering the recent and relevant research, then it's crucial that we as family practitioners are also able appropriately to analyse this information during the course of any hearing. We can and should continue to raise issues relating to post-adoption contact through the care and placement proceedings and the adoption proceedings. And we must hope that prospective adopters and adoption social workers familiarise themselves with the developing research showing the benefits of post-adoption contact and how changes can be made on the ground. And this needs to form the basis of some realistic training for prospective adopters around post-adoption contact. And finally, we should consider making more application for contact orders alongside placement orders under Section 26 of the Adoption and Children's Act, so that the issue of post-adoption contact at a realistic frequency is identified and discussed with potential adopters at an early stage in this process. And just on a separate note, there are some research, or there is research underway at the moment in France and Spain in respect of the benefits of open contact adoptions, but as yet we haven't got that far in the United Kingdom. So I'm going to move on now to contact post a care order. Under Section 34, all will know that there is a duty on the designated local authority to provide parents and certain other persons, including those with parental responsibility, with a reasonable amount of contact. The Children's Services has general duty to promote contact with wider family members, such as grandparents and siblings. And a child in care can make an application for contact with another child under Section 8 of the Children Act. The court can either order that contact takes place between a parent or a relevant person and the child, or order that the Children's Services is allowed to refuse contact. The court cannot, however, order that there be no contact between a person and a child if Children's Services are consenting to that contact taking place. Reasonable contact is not the same as contact at the discretion of the local authority, and we will all have had many cases where the local authority put forward a contact proposal which is not reasonable in terms of what parents are expecting or have had previously. Reasonable implied contact was agreed between the local authority and the parents, or in the absence of an agreement, contact which objectively was reasonable, and that was set out in Re-P. Because there is no definition of what is reasonable contact, and what is reasonable to one parent may not be reasonable to another. So in view of the statutory duty to promote reasonable contact, it should not be necessary to make an order imposing it. This is what the court said in Re-S. Unfortunately, there are occasions when applications have to be made because the local authority is not providing what could be considered to be reasonable contact. The fact that there has to be long-term supervision of contact is not in itself a reason to refuse direct contact. I'm going to move now on to a contact post special guardianship order. I've set out here what the provisions of making a special guardianship order are. I'm not going to go through those. I just included them for completeness within the slides. So I'm going to go on to the support services because it's usually within the public law domain that we find the support and the local authorities' recommendations for contact will be in the support plan. The support plan, it comes under section 14F of the Children Act, and as amended, it requires the local authority to make arrangements for the provision of special guardian support services, including assistance, mediation services in relation to contact between the child and their parents or relative, or any other person with whom the child has a relationship that the local authority considers to be beneficial to the welfare of the child. And that can be an extended family member, or it might even be, dependent on the child's age, a friend that is particularly supportive to a child who's moved out of area, and then the local authority are looking at maintaining that relationship. The local authority should also provide guidance as part of the SGO agreement in respect of contact, although ultimately, unless a child arrangements order for contact is made at the conclusion of the grant of a special guardianship order, either in public law or private law proceedings, contact with the parents or any other family member or any other person remains at the discretion of the special guardian. Where there are disagreements between the special guardian and the parent as to the type and level of contact, the parent can apply to the court for an order under Section 8 of the Children Act, as they can in any dispute between parents or anyone who holds parental responsibility. In this case, the court can order contact between a child and their birth family, even if the special guardian opposes. The test for contact with a parent where there is a special guardianship order in place, it is the welfare checklist and the welfare paramount of the child. So if the child arrangements order is made, the special guardian must ensure that contact takes place in exactly the same way as any other parent or any person who holds a child arrangements order has to comply with a contact order. So must a special guardian. If the special guardian does not comply with the contact order, then the aggrieved either parent or person with whom the order has been made has the same recourse as discussed earlier in making applications for enforcement of the order and seeking that the special guardian, although it won't do the relationship any good, can be punished in the same way. And that now brings me to the end of my talk this evening on contact post-final orders. I hope you have found it useful. Thank you very much.